Okay, good evening. Thank you for joining me for this month's webinar, an introduction to estate planning for Aussies living in the United States. I'm Ashley Murphy, certified financial planner, accredited investment fiduciary, and founder and principal of Arete Wealth Strategists. So first thing that needs to be stated here is that this does not constitute financial, tax, or legal advice. This is general information for your observation, but really you'd be crazy to act upon what you see here because I don't know you, you're not my client, and there are so many particulars with regards to estate planning. So it's important that that is understood from the outset. So a little bit about me. I'm a tri-citizen, born in the UK, raised in Australia to an American mother, raised in Brisbane, so I'm used to the heat, thus living here in Minnesota is always a shock to the system. Went to the University of Queensland, did a dual degree in IT and business management, moved to the US, worked as a corporate financial analyst for a number of companies, including Babcock and Brown and Visa. Saw the light back in 2008, which is both a contradiction because I love what I do, it's my calling, but on the other hand, the timing wasn't the best. So anyhow, I persisted and continued with CFP studies and started on the CFA track. Worked in the back office supporting 16 advisors for a couple of years, so really learnt the ropes before I started my own firm in 2013. Been involved in the Financial Planning Association, working towards a graduate diploma in financial planning with Kaplan. It should be, actually, I think it should be completed very soon. I've attended the Financial Planning Association conference and I've been a member of the FPA in Australia on and off over the past decade. I've also been an associate professor at Berkeley and at Golden Gate teaching up-and-coming CFPs. And I've also been a regular conference speaker for the US FPA, XY Planning Network, and the Society of Financial Services Professionals as recently as October at the FPA's National Conference. I've been featured in the following publications. Okay, Arete Wealth Strategists LLC, who are we, what do we do? Really consists of two brands, so Arete Wealth Strategists and Wealth Strategists Australia, both are fee only. We're a registered investment advisory, which means we work in our clients' interests 100% of the time, not fee-based, which means receiving both commissions and fees. This is fee only. I'm also cloud-based, so that way I'm location independent, can work with clients all over the world and do. Virtual and in person, I've been in Australia twice this year, twice last year, and plan on being there twice next year. I have traveled to New York, San Francisco, Miami, St. Louis, Chicago in the past year to visit clients and do other work. And I have a presence in Minneapolis and I'm routinely out in San Francisco on a quarterly basis. So what are the differences here? At the Arete Wealth Strategists Australia, we are really the only registered investment advisor and certainly the only certified financial planner focused exclusively on Aussie expats based in the US. I am not licensed in Australia. I work with a number of partner firms there and am privileged to make referrals to the appropriate partner given a client's circumstance. And really we do financial planning and investment management for Aussie expats in the US and wholesale Aussies or Americans in Australia. Arete Wealth Strategists, this was really the initial business offering. That's where I worked with business owners and executives doing much more complicated domestic planning. And so you can see here that I'm prospective clients that are business owners, that are Aussie expat business owners, are really in the sweet spot. So our clients face a number of different situations. You can see that list here. This recording, I should mention, will be posted to YouTube. Typically takes us a couple of days to do that, but it will be up. So you feel free to come back and pause this and look at that in more detail. But here's an outline of what I'll be going through this evening. What is estate planning? This is an introductory presentation here. So we're going to start right from the top. What is probate? the need for estate planning and integrated cross-border estate planning, given the complexities that arise when you introduce two different countries and two different legal systems. So the issues for dual nationals: Australian and US estate planning similarities and differences, estate planning tools and techniques, and we'll look at the ones mentioned right there. So let's get into it. All right, estate planning. What is estate planning? It's the orderly process of transferring assets from an individual to beneficiaries, a single beneficiary or multiple beneficiaries, and ensuring those beneficiaries' needs are met upon that individual's death. So the right assets going to the right person at the right time. That would be the most succinct way to explain what estate planning is all about. Estate planning concerns include identifying the assets, naming your beneficiaries, establishing trustees and guardians, especially for incompetent or junior beneficiaries that are not of the age of majority, drafting appropriate documents, of course, so wills and trusts, tax planning, and life insurance. So the need for estate planning really comes from a failure to conduct proper, the need for estate planning is evident when there is a failure to conduct proper estate planning, which can result in serious complications to an estate. And you see this all the time. This is an extremely common occurrence, and the reason is this. It's the same reason people don't like paying for insurance, because they view it as an expense as opposed to a risk mitigator, an action that could really save money and heartache in the future. So one example of where things could go wrong would be no beneficiaries being named. That's okay. I say tongue in cheek. I like to have a sense of humor about this, because if you don't have a plan for your estate, that's okay. The government does, and they will distribute things as they see fit. So there's forcing assets to pass by probate. We'll talk more about probate, but we generally don't like it. Sometimes unavoidable, but generally don't like it because it's public. It's a public process. It's very slow. It's uncertain that, in fact, an asset will indeed pass to the intended beneficiary, and there's costs associated with that. So the wrong beneficiaries can be named. That's particularly relevant with regards to ex-spouses or kids that have become estranged. Beneficiaries may lose care and support, particularly an issue for minor beneficiaries or those with disabilities. Beneficiaries may lose future income and assets. That would happen in the instance of someone, perhaps a divorced individual who has not remarried but has in turn is cohabitating with another individual and would like to provide what's called a life estate to their surviving partner, but wants the asset transferred to their kids. If they don't structure things correctly, then the surviving partner could be found without accommodation in that particular instance. The estate may suffer severe tax liabilities and incur other unnecessary expenses. Absolutely, that is totally what would happen without an appropriate estate plan. So the need for cross-border estate planning, if it wasn't already complicated enough with the need for estate planning, let's get into it. The cross-border estate planning. So now we're talking about the possibility of probate in two countries and assets not being transferred properly or being transferred at all. And so here's where we need to be mindful to seek out the appropriate advice, because standard US planning techniques may fail to protect wealth in cross-border situations and can result in unintended and counterproductive results. I see that more commonly with retirement accounts, with people trying to be too clever by half, not understanding that the ATO, the Australian Taxation Office, paid no mind, why would they, when they were drafting their tax laws of how US retirement accounts might be treated. And similarly, the Internal Revenue Service doesn't recognize or care about superannuation accounts. And so we need to know how the two of those are going to integrate. Different scenario, but you see the same kind of situation play out in estate planning. So issues for dual nationals is determining which country's laws apply, where an individual is domiciled. We'll go into that. There's a hyperlink there for us to go to the next slide. What is the situs of an asset? Lovely Latin word there that we'll define and dig deep down into. What are the spouse's citizenship status? Super important. The US is always a fun country to talk about when it comes to estate planning, because the US is the only country other than Eritrea that has a global tax purview. So citizenship-based taxation, not residency-based taxation. If you live in Australia, yes, you're subject to paying tax on your worldwide income. That's fine. Few other countries don't have that. Costa Rica is one, interestingly. But if you're a US citizen, you are always a US tax resident. Doesn't matter if you're in Australia or Antarctica or wherever you are, you're a US tax resident. So we should be mindful of that. There are tax treaties, there are estate tax treaties between the home and host countries. Thankfully, yes, in the case of Australia, Australia was earlier, an early adopter of an estate tax treaty back in the 1950s. But Australia doesn't have an estate tax anyway, so the interplay of that gets pretty interesting. So yeah, we see that Australia's one of 16 countries. So let's quickly talk about residency. There are whole lectures that you'll hear, or that I hear at international estate and tax conferences, just dealing with residency. There's really that much to it. Okay, 3 different definitions. There's your tax residency, mostly based on the substantial presence test. Are you actually in the US? The reason I say that is because you can be an illegal immigrant in the US and still owe taxes. So substantial presence test for tax residency. It's a more relevant example would be a visa holder. If you're in the US, you got your E3 visa, you are a US tax resident, which means you now are obligated to pay tax on your worldwide estate. Or your worldwide holdings, not to be confused with estate tax, which is a different treatment altogether, and hence why we're here right now. Legal residency, the legal status you have in a country. So are you here on a visa? You are a resident alien in that case. Are you a legal permanent resident, or are you a citizen of the United States? And then, of course, there's estate tax residency. It's not really referred to as estate tax residency. It's mostly thought of as domicile. We'll define domicile in the next slide. So as I've got here, it's possible to be a resident alien for income tax purposes, where you've got to pay tax on all your income all over the world, but a non-resident alien for estate tax purposes, meaning you live in Australia or wherever you live, and you might still be hit with US estate tax if you own US situs property. That's particularly relevant, I think, not so much for Australians, but there's been a lot of investment in real estate from Latin America and China in the United States. Real estate is a classic example of a US situs asset. And so with greatly reduced limits on estate taxes, individuals that have purchased that property could, and no doubt are, in for rude surprises when they find themselves with a 40% tax bill above $60,000. So domicile, let me get straight into that. Definition of domicile. It is really where you intend to live. That's the long and short, in the long term. This is where is truly your home. And it's done by a facts and circumstances test, taking into account a variety of factors. Statements of intent, length of your residence. If you've got a green card, well, that's a permanent resident. It's written in the name of the green card, permanent resident status. So that would imply you immediately, with few exceptions, have obtained your domicile in the US. Style of living in the US and abroad, ties to former country. I mean, all sorts of different things that can determine where your domicile is. This is particularly important, not so much for US citizens, but for the visa holders and people contemplating getting a green card. So situs of an asset. Situs, Latin word, as you heard me say, position or site, it's where an asset is deemed to reside. It also, in turn, determines the taxation of that particular income in given situations. And I say in given situations because the situs of certain assets is so specific, I had trouble even categorizing it. It's in the case of bonds, bonds is a great one. Non-government issued bonds are US situs, whereas government issued bonds are non-US situs. It's really specific on the asset. So but let me return to my example there with regards to the situs of an asset and the source of that income. If you own Australian investment real estate, for instance, you're going to be paying Australian tax on that, and then of course having to do a true up in your US tax return because that's Australian sourced income. Income earned from assets is taxed first by the country in which, well, as I was just mentioning a moment ago, and if it's effectively connected, and there's whole white papers written on this topic of what's effectively connected income to another country may be subject to tax by that country, even if the recipient has moved away or was never even resident there in the first place. Yet again, that goes back to my example of the Latin American and Chinese ownership of real estate in the US. Doesn't matter that they've never been here. If they own it, it's considered to be US situs asset, a US situs asset. So let's just go through what some of these US situs assets are. I think the graphic there is quite appropriate. So real estate, as you've heard me say, qualified retirement plans, tangible personal property, so the cars, of course, artwork, collectibles, US issued stocks, and note non-government bonds. There was a carve out in 1989 for government bonds, so they're not considered US situs assets. Intangible personal property, what would an example of that be? I can only think of, say, a patent issued in someone's name. Life insurance cash value. I don't come across Aussie expats having cash value in their life insurance very often, but if it is, it's US situs for estate tax purposes. Business assets, annuities, and non-resident aliens. There's that charming term. I prefer to say US people and non-US people, but non-US domiciliaries are taxed only on the value of their US situs assets. So if you're not in the US, but you spent many years living here and you accumulated any of the above property, that may be subject to US estate tax. We'll get to that as to what US estate tax actually is, because under the current estate tax exemption, it's really quite high. So similarities between Australia and the US. Let's get into it. More similarities than differences. For example, there is such a thing as probate. That is the public, slow, uncertain, and costly process whereby a will is read and determined by a judge to validate that will. So assets avoid probate when they're held in an account or trust with a named beneficiary, i.e. if you open something in a joint account or tenants by the entirety, there's already a successor owner of that account specified there. And I include the gavel there to indicate the determination that the judge makes in the process of probate. So common assets that avoid probate would be bank or brokerage accounts held with a payable on death or transfer on death title. That means, and we encourage clients to do it where appropriate, you can actually set up the title of the account so that instantly, as soon as a death certificate is presented to that custodian, then the transfer of assets takes place. Doesn't need to go through the will, which is fantastic. Life insurance, same thing, passes by contract, not through the estate, unless the estate happened to be named as the beneficiary. That would be a misstep if that happened. And of course, retirement accounts, as we just saw a moment ago, they're US situs assets, but to set up a retirement account necessarily requires naming a beneficiary in the first place. Okay, all other assets pass through probate, such as assets held as tenants in common, personal property, bank accounts, interests in various corporate entities, life insurance if you've made the estate the beneficiary, and intestate property. So, and certain ownership of business entities. There is a way of avoiding that, of course, and that is through what's called a pour over will, where you say, all my other assets go into my trust and will therefore pass to the intended beneficiaries, thus avoiding probate. Given that I'm a financial planner, obviously I take a financial lens when looking at a lot of these problems. Estate planning is a whole discipline unto itself, but I tend to be very forthcoming in my recommendation to do with obtaining a trust, and certainly a will that integrates with a trust. And the reason being is that above a fairly low level in California in particular, above a fairly low level of assets in an estate, and note that's not net worth, that's assets. So even with a mortgage on a house, we're talking about the value of the assets, not the estate. The probate fees can and often are more than the cost of setting up the trust in the first place. So if your thinking is you are concerned about your beneficiaries and passing on the largest estate possible, then the way to do it would indeed be to set up a trust, because you're going to be saving on the cost of the fees. The probate fees, that is. Okay, so estate tax. Let's talk about that. I alluded to this earlier. With the Tax Cuts and Jobs Act of 2018, it was raised to 11.4 million for an individual and 22.8 with spousal portability. What's spousal portability? It means if you die and you haven't used your 11.4 million, your spouse, there's an unlimited spousal transfer for US citizen clients. They can then use your unused 11.4 million, thus giving them 22.8 million before they're on the hook for 40% of their estate worth more than that. Needless to say, this doesn't affect a vast number of individuals. Interestingly, I'll just click out of this presentation for a moment. There's also states that have estate taxes as well. So if you're living in these northern states of the United States, you might want to think about heading south or engaging an estate attorney and financial planner to think about what you might do so that you don't get hit with federal and state estate taxes. It's a tongue twister, that one. Okay, back to where we were. Australia doesn't have an estate tax. And some Americans can get duped by this one. That is, in fact, true. But Australia's got a worse situation, or more taxing might be better than saying worse, in that only a few assets get a step up in basis in the first place. So a stock portfolio, as we'll see in just a moment on the next page here, in the US would get a step up in basis to the fair market value at the date of death. So the beneficiary, I'll just hold on a moment. I've got a graphic to illustrate this point. But in Australia, intangible assets, meaning stocks and so forth, do not receive a step up in basis. So it was the fair market value at the date of acquisition of the owner of the original owner, the deceased owner of that property. So here's how things work in the US. So dad purchased stock back in 1990. His basis is $100. Then he died in 2020 and the stock had doubled in value to $200. The child or the beneficiary inherits that and their taxable basis is now $200. The same example in Australia would be, the basis would be $100. And remember, capital gains tax works very differently in Australia, particularly for non-residents, where it's 32.5% on a graduated scale from the first dollar. But in Australia, the capital gains exemption for assets held more than a year is half of your marginal rate. So you're paying half of your marginal rate all the way back to $100 in this example. Now, don't get me wrong, that doesn't apply to every assets, particularly primary residences are an exception, or can be an exception, I should say. That again is the subject of another whole webinar to get into that. This just great complexity. So retirement accounts. With superannuation, here's a difference. You have, even with a binding nomination, it's important to state, default nominations in a superannuation account are non-binding. It's up to the trustee of the super fund to determine who that account's going to be paid to. Whereas with a binding nomination, they lapse after 2 years. Not the case with the US. where you have to name that beneficiary right from the outset. But interestingly, and it introduces a different set of problems, as you might imagine. You've got nominations that never go away, and thus, for the case of estranged children or ex-spouses, that can introduce some uncomfortable problems if people haven't been paying attention to who the beneficiaries are on their accounts. Taxation. So let's look at this. Retirement accounts here are inherited with proceeds withdrawn by the beneficiary's income tax. That's recently come down. They've used to be that you'd be able to take a retirement account distribution over the course of your lifetime. There are several other rules, but over the course of your lifetime in periodic installments. Now that's been compressed down to 5 years. So that's how things are done in the US. And then in Australia, as I had the misfortune of finding out, if you're not considered a tax dependent of the deceased, then your beneficiary, the amount you're going to receive from life insurance and from someone's super's account is subject to tax at 15%. Not so in the US for life insurance, at least. We've just mentioned how it works with retirement accounts. Okay, in the US, we also have a different type of treatment for couples, common versus community property states. Most notably for my client base is California, where essentially it's a community property state. Therefore, practically not any. There are some exemptions, but most property or interests or debt that's taken on as a couple remains as jointly owned. Whereas Australia and other US common law states, it's a little bit difficult to pass along property, particularly if there's a disagreement between spouses. Okay, strategic asset titling. Let's talk about estate planning tools and techniques. Well, first of all, you've probably gotten the impression already that I think it's a good idea, where possible, to be efficient and streamlined and low cost in the administration of your estate. And how do you do that? By avoiding probate as much as possible. So you do that by having such account titling as transfers on deaths and other assets that will pass automatically or by contract to their beneficiaries. Minimizing estate tax. Now, things could change after 2025 when the Tax Cuts and Jobs Act is set to sunset. There's no knowing what will happen at that point in time, but the estate tax is probably going to change from 11.4 million. It could be higher or it could be lower. It has historically been much, much lower, as recently as 2010, down at $2 million. That is a global net worth of more than $2 million subjected you to a 40% estate tax, is what it used to be. Take advantage of annual and lifetime gift exemptions. So currently the lifetime gift exemption is equal to that estate tax exemption. So 11.4 million per person. That is plenty of money to give away. Control disbursements of one's assets by obviously creating compliant wills and trusts. Life insurance is really a way of creating an instant estate for beneficiaries. Permanent life insurance, I have recently come around to actually liking it, having been a former professor in risk management and very rarely finding a case where I would recommend a whole life or universal or index universal or variable universal life insurance to a client. I was recently converted to change my opinion on that one for a very specific reason to do with retirement income planning that I'd be happy to talk about with a client. But anyhow, it's an important point to know. This has also been mentioned in a former webinar I did on do's and don'ts. Getting life insurance in the US is really the way to go, even if you intend on returning to Australia, or I should say, particularly if you intend on returning to Australia. The death benefit is a non-US situs asset, and the other thing is the US has the most inexpensive life insurance in the world. It's just much cheaper to get it here, and even with the tax deductibility of premiums in Australia through super, you avoid, and this is the perfect presentation to make the point, you avoid that nuisance of the non-financially dependent 15% tax that beneficiaries are subject to in Australia. So it's another benefit to US life insurance. You have to be resident in the US at the time of applying, however. You can't, if anyone is listening to this subsequently in Australia and says, well, great, I'm going to run out and get some US life insurance, not so quick. There's a few more hoops to jump through. Okay, a will, of course, I'm not crazy about them given their tendency to go through probate, but for some property that isn't going to be scooped up in a trust or some other asset transfer mechanism, then this will be the way to do it. Other problems exist, such as the property may no longer exist. Maybe Grand sold that car and can't be bequeathed to the intended beneficiary because it's not there. Passes through title or to a named beneficiary. So it's something in a will references an asset that's actually separately transferred. So let's say Nan put her house in a trust, but then included the house in the will. Well, it's already passed by virtue of this other mechanism, so it's not, the property's not even there any longer to be transferred by the will. Or yet again, it kind of loops back on this third example of the properties in a trust already. So we'd certainly encourage and again have a network of qualified estate attorneys to help clients with putting together the appropriate trust and will documents. Okay, what is a trust? You know, my best friend in Australia, he happens to be a lawyer, and I've never heard anyone explain it this way, but he communicates what a trust is most effectively. He says a trust is like a FedEx box. It's like a FedEx box where the trust itself, if there's nothing in the box, it's really of no inherent value. But the box has presumably has property in it, has stuff in it. So there's the assets belonging to the trust. It has a beneficiary, that is the sendee, who that box is going to travel to, and it has the donor, the person who sent the box in the first place. And I guess we could think of, in this example, FedEx as being the trustee. They're the ones responsible for administering that property while it's traveling from the donor to the beneficiary. I like trusts. I like them because they increase the ability of the donor to control who gets what. They help reduce the possibility of kids getting assets, significant assets, and blowing them in irresponsible manners. Children from first marriages getting disinherited, or any other number of situations. So, of course, again, same recommendation, speak with an estate attorney and financial advisor to come up with a comprehensive plan. Keep your estate plan and beneficiaries updated. You know, life happens, things happen, marriage, property, starting, adding a family, moving internationally. All of this can change what you might expect to happen, and no one knows the date that they're going to die. That concludes tonight's presentation. I did want to make you aware of some other resources and how to get in contact with me. That would be coming to our website here, and let's just do it for fun. I'll show you here. There's going to be a pop-up very quickly to do with what type of prospective client you are, given everyone's needs are all quite different, but you can just click out of that, click on Contact Us, fill this out, and then at the end of this form will be a link to actually schedule a meeting, and then we can sit down and have a chat and see if we have a match in terms of us being the right firm for you. So next webinar, Estate Planning 2. Please feel free to come to the website. As you see over yonder, we have the key financial data sheet. Very helpful. The second page here includes Australian tax information. It's the only US Australian key financial data sheet that I know of. Here's on the website, we've also got a list of white papers. I am just putting the finishing touches on the second, well, actually it's the third white paper here on the pros and cons of managed fund investing in Australia versus the US. When and why and where you would choose to invest in one country versus the other. But also you can see one that is published, and that is the passive foreign investment corporations and how they affect U.S. resident Australian expats. You saw that. That's how to get in contact. And that's a wrap. I'm going to take some questions, and I'm